Fine print, this is a joke, by the way. This is called procedural unconscionability. Fine print in contracts cannot be upheld. By the way, I'm an attorney. This is what it really says. Whatever I tell you legally, you can find your own attorney to get the real truth. Anyway, I should give you a little backdrop. I am an attorney, been an attorney for 35 years, member of the Pennsylvania and Florida bars. Most importantly, though, I spent 16 years with the Florida Attorney General's office investigating and prosecuting car dealers. The last 12 were with Reynolds and Reynolds. So working with forms. Okay, in 1940, you only needed one form to sell and finance a car, right? Today, 39 feet or more of documents for every deal, right? And you gotta do it fast. You know, you go through this whole palaver of documents, and how many documents are in a typical deal jacket? 39 feet or more, all of these various documents. And there are more documents now than ever. Why? Because there are more laws. And every new law that comes out, you have a new form that applies, right? Okay, what do they all look like? All kinds of shapes and sizes. Why are they so long? We'll get to that. That's for consumer law purposes. And, okay, you know, why care? Here are the processes, features. These are the talking points that I'm going to go over. Okay, why care? Because no matter what happens, electronic or otherwise, there are always going to be documents, just like currency. You always need words on a page. A lifespan, how long do those documents mean anything? After the consumer leaves the dealership, it could be 20 years because of RICO statutes, Racketeering Influence and Corrupt Organizations Act. Because if you find an infraction, and if you're investigating a car dealer and there's an infraction in the past 5 years, they can go back another 5 years. If they find infractions in the other 5 years, they can go back again and again. So this stuff, it lasts a long time. And third, you know, last low employee service final defense. Someone's going to be looking at your files. You're talking about auditing. Think about somebody who doesn't like you is looking at your files and wants to find something bad about you. That's why these documents are important. One of my old cases is 1994. One dealer, $532,000 and $1994 on 171 deal jackets that identified. I'm also an accountant. Identified problems. I mean, tremendous amounts of money at stake. And that's just money going back to the consumer. That's not the fines associated with it. Okay. Well, last time someone read your documents, who drafted them, how often do you review your documents? Is someone assigned to do so? There should be. Do you have an appointed compliance officer? Every car dealer in the United States should have one because of the red flags rule and the safeguards rule. Both federal laws require them, but it just makes good sense to have them. All right. Know your processes, completing, obtaining, papering. And papering on everything. Now think about this. As an attorney, when you draft a document, a contract, you want to consider all the contingencies. What might happen? The worst case scenarios. If you have it all in your documents, you're safe. If you don't, there could be an awful lot of liability. And that's where documents play a key role. How do they work together, and how do they protect the interests of the dealer? And once again, documents read by others. What are they going to find? I mean, in a pre-printed document, things you want to note. There's a print date. There is an effective date, very important effective date, because if you're using documents that are no longer effective, guess what? You're in violation. Why are they long? Because of consumer law. Consumer law is like this. In the old days, it was caveat emptor, let the buyer beware. Today, it's UDEP, unfair deceptive acts and practices. So it's not fair anymore. The merchant, the consumer is favored from the start. So that merchant, car dealer, has to make up for that difference, no longer caveat emptor. So, you know, the text and fonts have to be right, because sometimes the statute says there's certain text. The front and back, face and backer. The back is important as the front. Simple language, 10th grade level, it should always be. Copyright, you know, if you don't have a copyright symbol on a document, is it still copyrighted? Answer, yes. Because you get theft in documents all the time. Verbatim language, I point that out. You know, there's language that comes directly out of the statute or the regulation, has to be exactly right. So if someone's not reading that carefully and putting in your form, a problem. Language translations, that's a real problem. Single document rule, what does that mean? A lot of states have single document rules. That means that all the documents together in the transaction are part of a single document. In California, up until a few years ago, it was one page. It was interpreted. Okay, so these are very important considerations. So all of this matters, regardless if they're printed or electronic. Doesn't matter. Doesn't matter. So if you're signing electronically, we're going to get to that in a minute. Doesn't matter. Okay, going the wrong way. Let's see. I'm going to go back. Okay, these are just a sample of the laws, federal laws. All of these, and like, you know, the Federal Trade Commission Act, look what happened. They just changed the buyer's guide, truth in lending, the holder due course rule, UDAP, very important, unfairness, setback, and practice. RICO, I used RICO a lot. It's a great way to get after dealers. Okay, buyer's guide, a new document. They changed this recently. That has to be on the used car. Every used independent dealer here, if they're not using the updated document, they're in trouble. All right? And they don't post it properly, they're in trouble. English and Spanish. Foursquare. This is a preliminary document. And I'm just going to point out that this is the document, you know, someone goes in and they work up the deal, first pencil the deal, all right? Why did they leave it in the file? They were my best cases because they were, the ones they were doing it incorrectly, they were misrepresenting the terms and conditions, you know, the cash down monthly payments, all that. Get rid of it. If you don't want to get rid of it, fold it over and mark it, staple it, mark it superseded. Because what's a friendly attorney general going to do? He's going to nail you on that. Buyer's order, this is a contract to sell a car. Dealers use this incorrectly. It's a contract to sell a car. And you sell a car in cash, or you're going to sell it under some kind of retail note, or you're going to lease it, right? But this is preliminary, a contract to sell a vehicle. Arbitration, we just had a wonderful arbitration victory. I don't know if you followed that, but the CFPB was going to have a new rule which would deny the right to have class action waivers in arbitration. Well, guess what? 50-50 vote in the Senate, decided by Vice President Pence, 51-50, overrode the Bureau's arbitration rule. Dealers are safe. Tremendous victory. And someone should be really speaking about here at this conference, about what a wonderful development this is. Okay, lease order. If you're going to lease cars, you don't want to use the buyer's only lease order. Leasing is different. Terms are different. Retail and someone sell contract. But 80% of people finance their cars. 80, probably more like 70. You know, leasing's taking a big role. This has to be very carefully followed. These documents change a lot. Rental produces in all 50 states. They change on a monthly basis. They always have to be updated. Good point here. This covers cars of $54,000, $55,000. If you sell a car for $57,000, you don't have to follow the truth in lending. You don't have to use this form. You can use it, but it doesn't mean to say you're going to have to be held by truth in lending. Because truth in lending is what? Consumer Act for retail. So commercial vehicles? No, you can use it. It's used every day for commercial vehicles. Now here in California, it's $100,000. Other states just follow the Truth in Lending Act, and it's indexed. It used to be just 25. It's been indexed. So, okay, consumer lease contract, same idea. Consumer lease contract is longer than a retail contract. Deal recap. This is where the profits are shown. I mean, these dealers, they put things in there. They brag about ripping off consumer. I mean, it's the craziest things. Don't do that. We owe. This is a simple little form. You finish your deal, everything's done, but there's something that has to be added to the car. Okay, so new pinstriping, or you buy a pickup truck, new bedding on, something like that. Just stick to the terms. There's a case where someone said 100% guarantee satisfaction. That was concluded in a court, a special warranty held against a dealer. Just keep it to the facts. Other important documents, notice to co-sign, agreement first, insurance, communications authorization. Very important now. The third bullet point, the TCPA, the Telephone Consumer Protection Act, has been changed. If you don't have permission to call somebody $500 fine, Spanish interpreters. This one right here, privacy notices. The federal government went and decided they're going to, FTC decided they're going to update the privacy notice. And you can go on their website and you can make one up by yourself. 98% guarantee you're going to get it wrong. This law produced 288 different privacy notices. How do dealers get it right? I guarantee most dealers have it wrong. Ancillary product, DMV form, adverse action notices, that's from the last 10 years. Red flags form, last 10 years. We love forms, by the way. We're in the forms business. But dealers, they run the risk of getting these things wrong. And they get them wrong, there's tremendous liability. Okay. You talk about electronic. The future, paper electronic. These are two acts. Electronic Signatures and Global and National Commerce Act, e-sign, federal act, passed in the year 2000. Uniform Electronic Transactions Act, ETA, that's state, right? Anytime you see uniform on any act, Uniform Commercial Code, that's an act that was drafted by the National Conference of Commission on Uniform State Laws. And these brilliant guys all get together by all the states and they design state law. It's a terrific process, and that's what they come out with. UETA was passed in 1999. Almost every state, 48 states have passed it. Why is it here 2017 rather, we still don't have total electronic documents? Good question. A lot of reasons, one of which is DMVs don't like them, and no one wants to have a deal jacket that's part electronic and part paper. Dealers are used to doing things with paper, and it goes on and on. Anyway, what's important to note, all these terms that you saw on these forms are required disclosure, and they're always going to be necessary. It doesn't matter whether it's electronic or paper. And you know, the manner of providing the documents remains the same. You've got to, there are dealers now who just have people sign, and then they'll send the documents to you later. No, that's a total violation. And there's some Mercedes-Benz dealers that are doing it. They're going to get nailed. You know, the process is very important with electronic, and by this is what's called DocuPad. Terrific way to do this. It's a Reynolds product, I'll point out. All right, think about this. You're now going to be investigated. The worst thing in the world is to be investigated because guess what? The investigating agency is not going to stop with the complaint. They're going to look at everything. They're going to stick their nose in all your business. I went undercover as a finance manager a couple of times, undercover as a salesman place, undercover as a consumer many times. I could go to any dealership in the country and find something wrong. Why? There's just so many laws to follow. It's not because they're not trying to do it right. They're just going to, you're going to find, so you don't want government looking at anything you do. And they're going to audit more than deal jackets, spreadsheets, it's fines, legal fees, it's restitution. It can be very, very costly, as I pointed out earlier. Qualitative and quantitative. Other documents, deal jackets should be signed with the consumer or blank. Why would you do that? If they're not relevant, you destroy them. Other executed documents conflict with one another. Let's say you have two separate buyer's orders. One superseded the other. Get rid of the first, right? Why dealers do this, I have no idea. And the cost of investigations is also part of all this. You pay for the investigation. Okay, criminal violation, truth in lending, $5,000 if or you're in jail. But look at this one. The FTC, that used to be $11,000, now it's $40,000. They've raised that 4 times over in the past 5 years. State UDAP, up to $25,000 per infraction, plus legal fees, costs, and restitution. I mean, I got back over $15 million of consumers just from car dealers in my 16 years. It wasn't hard. State RICO, forfeiture of assets, that's a great one because part of RICO, Racketeering Influence Corrupt Organizations Act, you could take the property away from somebody. Class actions, we all know about class actions, what a wonderful vehicle that is to rip off businesses. Civil and criminal fraud and theft. There is civil theft and civil fraud, interesting concepts, which can lead to tremendous fines. The Dodd-Frank Act, it applies to almost every dealer at this conference. $5,000 each day of the violation. If it's a reckless violation, 25 grand, intentional violation, $1 million. These fines are not for getting money back. These fines are to put someone out of business. So the Dodd-Frank Act really goes way beyond previous law. So what did you do? Documents keep you compliant, protect you, make the sales process easier, more effective. And here's really important. If someone conduct a review of the 20 or 30 documents you use in every deal jacket on at least an annual basis, you should be doing that. Does that attorney review the 40 or more state and federal laws that affect documents because they change regularly? Do your documents support your dealership's processes? Every dealer is different. I mean, some dealers, they hire a new general manager or sales manager, and they want to change things. Do they have a protocol on how they change their documents? This guy might come up with an idea, oh, I like this from my former dealership, we're going to put it in our new buyer's order. Well, he's not an attorney. He might put a paragraph in there that totally destroys one of the defenses a dealer may have. Conflict in language. So the number of documents out there is staggering. Reynolds & Reynolds, we print over 100,000 different documents throughout the country. As I said, you look at the deal jacket today versus what it was 20 years ago. But dealers should use as many documents as needed, no more, no less, to make sure they are insulating themselves from any potential liability. And that's what this is all about. The documents work together, and they could foresee the foreseeability of problems like 5 years from now, 10 years from now. Could there be a problem with that file and many files because they're still alive? Thank you.